So we respectfully submit that the only way that the Grand Chamber can identify the dysfunction and to ask Turkey to cure it is to say to Turkey, you must repeal Article 159 of your constitution. That is the answer. It's been the answer since the days of Louis Zidou. You must repeal Article 159 and you must allow all Greek Cypriots to return to their properties. What the court cannot do is take up this alternative of the 2005 law, which, as I've submitted, is simply based on ethnic cleansing and getting the court to agree with that. Now, I want to now turn to my second main point, which is the effectiveness, and I want to focus on two principal matters. First, restitution, and secondly, compensation. Dealing first with restitution of property, as the court knows from the Louis Zidou case and the Fourth Interstate case, restitution should be the primary remedy. But as Turkey in its memorial accepts at paragraph 139, and indeed Sir Michael candidly accepted this morning, in many cases, restitution under this law is simply not possible. There are a wide range of circumstances where it's not possible. What are the examples? First of all, if property happens to have been transferred to a third party. Secondly, if restitution endangers national security or public order. Thirdly, for the vague criterion which is set out as property being allocated for public interest reasons. And fourthly, if property is allocated or located in military zones. Now, we say that when one looks at those exceptions, they show that restitution is very, very rarely going to be awarded. If I can take just the first point, which is the fact that the property has been transferred to a third party. Now, we say it is no answer to a right to restitution to say, I'm very sorry, but your property has been transferred to somebody else. And Turkey gives the example, and Sir Michael gave it this morning, the example of refugees. And of course, one feels great sympathy with refugees, and their needs must be met. But what is the justification, we ask, and Sir Michael has no answer to this, what is the justification for giving refugees title permanently to Greek Cypriot property? They may need to be housed temporarily, but there can be no justification for permanent transfer. Yet, as Sir Michael appears to accept, that's the effect of this law. Equally, why should property that's in military zones be excluded? That type of limitation entrenches the violation suffered by the victim, which at its core is the occupation of his property by a foreign power under military force. Also, there is no indication in the law as to whether or not the IPC is able to question whether a property is properly classified as being in a military zone. So we say that when one looks at the actual exceptions to restitution, the right to restitution effectively disappears because there are so many exceptions. Now, my second and final point concerns the levels of compensation, and I must take serious issue with the approach that Sir Michael took to the evidence that we submitted as long ago as February. Sir Michael, for the very first time on behalf of the Turkish government, is suggesting that the witness statements and the valuation report are not to be believed. We ask, what had the Turkish government been doing since February 2009? Why is it only this morning that we hear them say that that evidence is not to be believed, that the valuation reports are inaccurate or self-serving? This is a court of law. It acts on evidence. That evidence we submit, in common with Mr. Anderson, is uncontradicted. A crucial element in that evidence, which I must underline for this court, is the percentage of 3 to 6%. That percentage reflects the amount that this commission is paying by way of compensation when compared to the true value of those properties, not derived in a self-serving way by Cyprus, but according to international and European valuation standards. So at this very stage, the Commission only gives between 3% and 6% of the actual value of property. And since October, Turkey's put forward some further examples in some lately submitted evidence of further awards that have been made. We've answered that evidence and we will submit it to the court. But that shows, that evidence, and I give an example here, that of 23 cases where the Commission's awarded compensation, they've awarded a total of €31,000, whereas international valuation standards show even on a conservative basis, they should have awarded in excess of €200,000. So we respectfully submit that the 2005 law should not be recognised as a matter of principle because it is premised upon the legality of ethnically based appropriation of property and also because it's ineffective in practice. Before I sit down, I shall just mention one final matter, which is that even if this court, contrary to our submissions, were to decide that the 2005 law is to be given some form of recognition, it will not remove 1,400 property cases from this court. That's because, as this court has recognised in established jurisprudence, and in fact most recently in the case of Burdov and Russia, a court's ruling now cannot render inadmissible applications by people who made their applications to the court many years before this law was put into place. In Burdov, the court rightly said, when it recognised a remedy, the remedy is only effective and should only now apply to those applications made after the judgment of the court. And we respectfully submit that is the approach which this court should adopt if it rejects our submissions. Mr. President, I'm grateful for the opportunity to make submissions. I now hand over to Professor Lowe.